Hello, my name is Tom Beto. I'm a board member of the James E. Holshouser Lecture Series. Walter Bull is the founder and the godfather of this series. Other board members are John Rowerdink, George Little, Larry Cadell, Stephen Lader, and Jim Busby. Today's lecture on property rights is the second virtual lecture in the series. The first was done just about a year ago on the science behind COVID-19 and was surprisingly predictive of the virus's evolution and the timing of reaching herd immunity, hopefully very soon. You can watch that lecture on jehlectures.com if you'd like. Our first live lecture was given in September of 2021 by former North Carolina Governor Jim Martin. He was our 70th governor and focused on the life and accomplishments of his predecessor and our series namesake, James E. Holshouser Jr., who was the 68th governor of North Carolina. Our second live lecture will take place on March 18th, 2022, here at the Bradshaw Performing Arts Center at Sandhills Community College. I'm very pleased to announce that our speaker will be Dr. Ben Carson, and his topic will be the critical role of education in the preservation of our republic. Humble beginnings in Detroit, Michigan, to a renowned neurosurgeon and an esteemed public figure. There's no better example of the importance of education. Tickets for that lecture will be available soon on jehlectures.com. I might add that the lecture series is a 501c3 organization, so tax deductibility is in place net of any costs. Today's virtual topic is property rights, the fundamental building block of our free enterprise system and of our freedom. My good friend Charles S. Webb III will lead the discussion with local attorneys, also good friends, Stephen Lader and Maureen Krueger. Charles recently retired from his New York City law firm at the young age of 90. His keen knowledge of property rights was honed in complex public-private property cases in New York. Who are you going to call if you want to build a new subway tunnel under the Hudson River from New Jersey to Manhattan? And to untangle who owns what both above and below ground? You're going to call Charles Webb. Those of you who know and love the quiet, low-rise simplicity of Emerald Isle on the North Carolina coast can thank Charles for crafting their town charter and architectural standards years ago. Charles will cover the history, the constitutionality, and the threats to property rights that we are now seeing today. I hope you enjoy the discussion, and thank you for your support of the James E. Holshouser Jr. Lecture Series. If you would like to be a founding sponsor of the series, you can do so at jehlectures.com. Thank you very much.
Good afternoon. My name is Charles Webb. I'm an attorney, practice law in many areas of the country, and spent many different times reviewing the constitutional rights of property.
Thank you for letting me join you today. I'm Maureen Krueger. I was the district attorney in Moore County for 14 years. Was an assistant district attorney and owned my own private law firm. I've been self-employed in various businesses over the years and have a passion for the Constitution and for our personal property rights, and I'm very delighted to join in this conversation today.
My name is Stephen Lader. I'm a lawyer in private practice here in Moore County, North Carolina, and I had worked previously on Capitol Hill, and probably kindled my interest and passion for the Constitution and its role in protecting the freedoms that we enjoy here in the United States.
Let me begin by discussing the history and development of private property under the Constitution of the United States. Constitutional democracy in the United States has been characterized by a high regard for the rights of property owners. Alexis de Tocqueville, the French commentator on American society, in his treatise Democracy in America, politically observed in 1840 in no other country in the world has the love of property keener or more alert than in the United States, and nowhere else does the majority display less inclination toward doctrines which in any way threaten the way property is owned. Historical evidence demonstrates that a regime of private property is a vital prerequisite to the establishment of democratic government. In 1775, Arthur Lee of Virginia stated that the right to property is the guardian of every other right, and to deprive people of this is in fact to deprive them of their liberty. Alexander Hamilton stated, "One great objective of government is personal protection and the security of property." John Rutledge states, "Property was certainly the principal object of society." A strong belief in the need to defend the rights of property owners was a paramount value for the framers of our Constitution. John Adams expressed the view very succinctly in 1790 when he said, "Property must be secured or liberty cannot exist." John Locke, the 17th century English political theorist, was very influential to the framers of our Constitution. He insisted that the right to own property, together with the rights to life and liberty, were natural rights which existed before the establishment of political authority. The ownership of property was revered by our founding fathers as a fundamental or natural right just as important as life and liberty itself. Even though the signers of the Declaration of Independence did not include property in their opening declaration, we hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain inalienable rights, that among these are life, liberty, and the pursuit of happiness. Nevertheless, it was the right of ownership of property, not the property itself, that was inalienable. Property itself is alienable. As we know, the word alienable means it can be transferred, like you sell property, but the right to own it is inalienable. And just as a side note to the pronouncement by the declarers, I'm always amazed at the gall some plaintiffs and their attorneys have in seeking to enforce their constitutional rights in certain civil liberty cases. The Constitution doesn't give citizens inalienable rights. It is acknowledged that they are endowed by their Creator. The Constitution merely protects those rights and assures its citizens they will not be abridged or taken away. Yet picture the atheist or even the agnostic in court on a civil liberties issue, insisting on their constitutional rights, failing or refusing to accept a supreme being, but at the same time demanding their endowed rights which came from the very Creator that they didn't believe in. Any comments?
Well, our founding father certainly set the framework, and especially when we look at the writings of de Tocqueville, when you look at what they were trying to create from a distance, they knew based on what they've seen in other democracies, the failures, the rise, what worked, what didn't work, that those private property rights were going to be fundamental to the success of the country and the success of our personal liberties. To think otherwise, and we know that our private property rights are subsumed in the right to liberty that is espoused in the Declaration of Independence. That, of course, if you're not secure in your private property rights, then you have no security whatsoever. And we had some remarkable people looking after this country and shaping it in the beginning. I think everything that you said was so just hit right at my heart of why we love this Constitution and why we protect it. It's not about owning property and being materialistic. It's about our natural rights.
And to think what a special role Western civilization plays, and to think that to the degree to which this is the many degrees the culmination of the evolution or the continuation of the evolution of Western civilization, and the notion that rights are endowed in us, by our Creator, inalienably so, not granted to us by government, not secured through any other way. And there are few places in the world where you would see that combination, not just of having that deep cultural background, but also to see it as part of the broader legal culture, governmental culture, and to have that combination just underscores how unique and how fortunate we are here in the West in terms of the liberties that many of us take for granted.
Going forward on those basic comments, which are very helpful, there are many Supreme Court cases and quotations from early colonial days to the early 20th century. And I point to the early 20th century because shortly we will get to another era called the New Deal, which was in 1957. But one reference which reflects the Supreme Court's thinking before that was stated by George Sutherland, appointed to the Supreme Court and speaking to the American Bar Association. There is no such thing as rights of property apart from the rights of man. The thing protected by the Constitution is not the right of property, but the right of a person to property, and this right to property is of the same character as the right to life and liberty. Justice William Patterson, in a case decided in 1795, that the right of acquiring and possessing property and having it protected is one of the natural, inherent, and inalienable rights of man. Men have a sense of property. Property is necessary to their substance and correspondent to their natural wants and desires. Its security was one of the objects that induced them to unite in society. No man would become a member of a community in which he could not enjoy the fruits of his honest labor and industry. The preservation of property, then, is a primary object of the social compact. Justice Joseph Story in 1829, that government can scarcely be deemed to be free where the rights of property are left solely upon the will of a legislative body without any restraint. The fundamental maxim of a free government seems to require that the rights of personal liberty and private property should be left sacred. Justice Stephen Field in 1890, it should never be forgotten that protection to property and to persons cannot be separated. Where property is insecure, the rights of persons are unsafe. Protection to the one goes with protection to the other, and there can be neither property, prosperity, nor progress where this is uncertain. And then, I pointed out, came the New Deal, or as legal historians have noticed, the Constitutional Revolution of 1937. Responding to the Great Depression, Franklin Roosevelt's New Deal program was predicated on the notion that the federal government should promote social welfare and manage the national economy, which ran counter to the traditions of a limited federal government and the rights of property owners. The Supreme Court, under great political pressure, began to uphold federal and state economic regulations. This new ideology was set forth in a footnote in a famous case which stated that the court would provide a higher level of due process protection to a preferred class of personal rights, such as free speech and religious freedom, than for property rights. Thus, the current trend of the Supreme Court at that time is to make property rights less protected than personal rights from the postures of the Supreme Court. You recall what's going on?
Well, it's very evident that this is a reaction to the culture of the time and the economic hardships of the time, that people were so willing to give up their rights just to have a little bit of security, and foolishly thinking that the federal government is going to provide more security than they can provide for themselves. And of course, I think that they took great advantage of the cultural decline at the time and the economic situation to trick people into thinking that this was a good idea.
And it certainly harkens back to what Benjamin Franklin warned 150 years prior. He who would give up a bit of liberty for safety or security will wind up with neither.
This then takes us to the next very important exercise of what we call fundamental rights. Fundamental rights are something that the Supreme Court, over its history, has determined, and once it's determined that a particular right is fundamental, that word fundamental prevents other legislatures, other governmental bodies from taking that right away from you. I will get into a number of different rights, but what is described as a description in a dictionary, fundamental rights are a group of rights that at the Supreme Court recognizes as being fair and legal, and they're also rights that are listed within the Bill of Rights. Here are some examples: due process, freedom of speech, freedom of religion, right of privacy, but then it goes further. Right to marry, right to interstate travel, equality, right to assemble, right to bear arms. Here are the others determined to be a fundamental right by the Supreme Court over the years. This may amaze you, some of the rights, but as I said, these rights cannot be taken away from you by legislation. And here they are. 1923, the right to teach German. As you know, right after the First World War, Germany was not a favorite subject. The right to go to a private school in 1925. The right to distribute pamphlets. City of Marin, a copy of this is in some of the other matters that I have. That's 1943. The right not to say the Pledge of Allegiance to the flag, West Virginia, 1943. The right to travel, Kent versus Douglas, 1958. The right to use contraceptives, Griswold versus Connecticut, 1965. The right to wear a t-shirt reading F the draft, that was Cohen versus California. The right to burn the American flag, Texas versus Johnson, 1989. And finally, the right to engage in non-traditional sexual conduct, Lawrence versus Texas, 2003. All these rights have been deemed fundamental and entitled to strict scrutiny if endangered by governmental action. None of these rights are mentioned anywhere in the Constitution, and yet are found by the court to be fundamental. The right to ownership of property is expressly protected by the Constitution, yet according to several recent decisions, is not a fundamental right. So balance my right to keep my house against my neighbor's rights to wear an obsessive, expressive t-shirt. If the framers of the Constitution were here today, which right do you think they would consider fundamental?
Well, it seems pretty obvious when you've got at least the Third, Fourth, and Fifth Amendment that directly deal with property rights. The government cannot, by Constitution, that Third Amendment, force you to house soldiers. We don't ever think of something like that coming up, but that was something that was pretty important to the framers, that they included that in the Constitution, that the government cannot force you to give up your house in order to house soldiers. Of course, our Fourth Amendment, as it protects your right against unreasonable search and seizures, it protects your personal property, your house. That, of course, has been expanded over the years to include other places, including digital information. And then your Fifth Amendment rights, your actual rights to due process, and nobody shall be put in peril of their liberty without due process of the law or have their property taken. So we have some very clear expressions in the Constitution that our founding fathers saw property rights as a fundamental right, enough that they included it in 3, probably some more that I'm missing, but at least 3 of the first 10 amendments. So that's pretty important stuff.
I think an interesting observation is that regardless of one's political philosophy, amongst the rights you named, people on both sides of that divide would probably see rights that would merit in their minds protection and fundamental status, and yet the fact that so much of that is not necessarily mentioned in the Constitution really underscores the importance of the textual approach. and remaining true to the language of the Constitution, lest rights be developed that one day we may agree with, other days we may not, and just underscore the risk of legislating from the bench or creating from the bench like that.
Let me next take you to something that is very, very alarming to me when it came out, and not many people realize it. But critical race theory is an academic discipline formulated in the 1990s, built on the intellectual framework of identity-based Marxism. Relegated for many years to universities and obscure academic journals, over the past decade, it has increasingly become the default ideology in our public institutions. It has been injected into government agencies, public school systems, teacher training programs, and corporate human resources departments in the form of diversity training programs, human resources models, public policy frameworks, and school curricula. But no one has pointed out, other than the educational theories involving critical race theory, that it involves in the sense of extreme terrorism, if we try to use it. There are a series of euphemisms deployed by its supporters to describe critical race theory, including equity, social justice, diversity, and inclusions, and culturally responsive teaching. Critical race theorists, masters of language construction, realized that neo-Marxism would be a hard sell. Equity, on the other hand, sounds non-threatening and is easily confused with the American principle of equality. But the distinction is vast and important. Indeed, equality, the principle proclaimed in the Declaration of Independence, defended in the Civil War and codified into law with the 14th and 15th Amendments, the Civil Rights Act of '64 and the Voting Rights Act of '65, is explicitly rejected by critical race theorists. To them, equality represents mere non-discrimination and provides camouflage for white supremacy, patriarchy, and oppression. In contrast to equality, equity is defined and promoted by critical race theorists is little more than reformulated Marxism. In the name of equity, and get this is where property comes in the name of equity, law professor and critical race theorist Cheryl Harris has proposed suspending private property rights, seizing land and wealth, and redistributing them along racial lines. Critical race guru Ibram X. Kendi, K-E-N-D-I, remember that name, who directs the Center for Anti-Racist Research at Boston University, has proposed the creation of a federal Department of Anti-Racism. This department would be independent, that is, unaccountable to the elected branches of the government, and would have the power to nullify, veto, or abolish any law at any level of government and curtail the speech of political leaders and others who are deemed insufficiently anti-racist. One practical result of the creation of such a department would be the overthrow of capitalism, since according to Kendi, in order to truly be anti-racist, you also have to truly be anti-capitalist. In other words, identity is the means and Marxism is the end. An equity-based form of government would mean the end not only of private property, but also of individual rights. Equality under the law, federalism, and freedom of speech. These would be replaced by race-based redistribution of wealth, group-based rights, active discrimination, and omnipotent bureaucratic authority. Historically, the accusation of anti-Americanism has been overused, but in this case it's not a matter of interpretation. Critical race theory prescribes a revolutionary program that would overturn the principles of the Declaration and destroy the remaining structure of the Constitution. Now, I want to go to something that's very personal as it relates to our leaders, but I want to give an opportunity to discuss critical race theory with our guests.
Okay, so I think the one thing about critical race theory that most people misunderstand or don't understand is that there is a common belief that critical race theory is an anti-racism program, which again is the kind of language that seems non-threatening and things that, a concept that everyone should embrace. Nobody wants to have racism. And so in common parlance, and people are looking at it as this is an anti-racism program, they don't understand that this is Marxism. And perhaps the most, to me, the most frightening part of that Marxist approach is what you refer to as the omnipotent bureaucracy, which would certainly divide us into two classes in which you have a power class and a powerless class, and that is all decided and distributed by bureaucrats. And to me, that is a frightening proposition, and of course is antithetical to all the principles of the Constitution.
I agree with Maureen. Just the inherent nihilism in this type of approach, and the denial of any recognition of historical patterns or past history, and to barrel ahead with something that would empower the government, on a level probably that would rival what you see in the People's Republic of China today. And the irony, of course, which has always seemed so evident and yet not readily acknowledged, is we have had in recent years presidencies with whom the advocates of critical race theory may not necessarily have been sympathetic, and so in effect, notwithstanding Professor Kendi's not terribly serious proposals in terms of the federal government, but to empower the federal government and state governments in some respect with this magnitude of power, despite the fact that some of these administrations, state and federal, have not been sympathetic to, much less advocates of these theories, seems almost blind to the consequences, and just blind not to history, but to as well to the ramifications of their very proposals. It seems remarkably short-sighted and simplistic in so many ways.
You put it so diplomatic, but I'm pretty sure that professor's head would implode if Donald Trump had the power that he suggested that federal government should have.
As part of my life of legal work, I was counsel to the New York State Assembly from 1968 to 1978, and was responsible for all of the legislation that came through that body. And I worked with both members of each party and its leadership under Nelson Rockefeller as governor. And one of the young men that came in from Brooklyn, and you would not think he would be an ultimate leadership quality, his name is Chuck Schumer. Started in the Assembly, went to Congress, then a total political service, I think, of 36 years now. And I've been writing some articles about term limits, and I think it definitely would apply to him. Listen to what he once said, and I saved this. Time and time again, we find progressive laws getting struck down, and it's always, always the ones the Constitution is against. These right-wing judges don't think for themselves. They just do whatever the Constitution says, and it's time for that to end. And another one, Elizabeth Warren. We need judges to be advocates of progressive laws, not people who will bow to the whims of the Constitution, putting its extremist values of freedom against our agenda.
Well, for so many years, I think we conservatives have voiced disappointment in varying degrees about the opinions and the votes of certain justices on the Supreme Court, the ones whom we had reason perhaps to think were more philosophically in tune with our expectations or with our thoughts, and yet what's really noteworthy is how infrequently that happens on the other side of the political spectrum or the philosophical spectrum. There seems to be a lot more ideological consistency on the left these days, more discipline, which frankly in a judicial context is philosophical rigor is one thing, ideological discipline is another. And I think that's certainly a cause for concern and indicative to some degree of the mentality or of the thoughts of Senator Schumer, for example, from whom you just read that quote.
I said years ago that if we could get the Supreme Court back deciding ownership of property is a fundamental right, we can then feel safe that dangerous programs such as critical race theory cannot succeed. And my prayers were answered on June 23rd, 2021 by a decision of the United States Supreme Court entitled Cedar Point Nursery against Hasid. And Chief Justice Roberts delivered the opinion of the court. Basically, it was a California regulation which granted labor organizations a right to take access to an agricultural employer's property in order to solicit support for unionization. Agricultural employers must allow union organizers onto their property for up to 3 hours a day for 120 days per year. The question presented is whether the access regulation constitutes a per se physical taking under the 5th and 14th Amendments. As we said earlier, much of the history of the ownership of property is developed through the laws of and the questions raised under eminent domain, because the question of ownership and how you may keep people out from your property is clearly defined in many of the cases similar to this one involving eminent domain. Two classes of eminent domain, just to point out. One is where they actually take the property and they must, for a highway, for proper public purpose. And there's many definitions of proper public purpose. But when they actually take the property for a road, for a school, for a museum, for many different reasons, that is acceptable under eminent domain, but you have to pay fair value for it. The type of question raised in this case is whether a regulation that permits certain persons to use your property without having to pay anything is raised under the eminent domain statutes, and that's where this came from. Now, the California Agricultural Labor Relations Act of 1975 gave agricultural employees a right to self-organization and make it unfair labor practice for employers to interfere with that right. The State Agricultural Labor Relations Board has promulgated a regulation providing in its current form that the self-organization rights of employees, including the right of access by union organizers to the premises of a right of access for the purpose of meeting and talking with employees, soliciting their support, is permissible. And the access regulation appropriates a right to invade the grower's property and therefore constitutes, under the decision of the Supreme Court, constitutes a per se physical enter and occupy the growing earth for 3 hours a day for 120 days wrong. Rather than restraining the grower's use of their own property, the regulation appropriates for the enjoyment of third properties the owner's right to exclude. I know we chatted earlier about this, but have any other comments about this? Once we determined that it was wrong and they had to pay compensation or go back and change the regulation.
I look at it from a political perspective in that at one time it was probably a very well-meaning idea to give protection to what are probably largely immigrant workers, people who did not have a lot of power, did not have a lot of access to courts, people who needed some kind of employee protection from abusive employers. I think there's, a pretty good body of evidence that there were at one time, or was at one time, a lot of abuse in that kind of industry. And we saw labor laws come into place that addresses abuses. But the political problem is where you give, I'm going to lump them all together as a non-conservative. If you give the non-conservative an inch, they take a mile. So each little encroachment into that private property right, they're going to go further and further and further. So whereas what started as a good idea, let's protect workers, turned into this melee, as was described in the Supreme Court case, that these people are coming in for hours upon time. They're interrupting the process of work. They're interfering with how the operations run. And so if you give them an inch, they take a mile and will encroach and encroach and encroach. And I think we finally saw the point where you've got a very good fact scenario of how horrible it was when the union organizers are coming in and really disrupting business. Not just, it's not a situation where people are going out to a bar together and talking about, hey, we should get higher wages, and then you've got the boss man coming in down on them. You've got union bosses interfering with the actual operation of this business. And thankfully, we didn't have a situation in other times where our conservative leadership on the bench came up with something we didn't expect them to. This decision is really much in line with an overreach that went so far as to make everyone step back and say, no, we've got to protect this property right, and the only way to do it is to consider it a fundamental right.
I think it makes some of us rather wistful when Thomas Jefferson, not then president, advocated for allodial ownership at the Constitutional Convention. That being said, as I recall, it was Madison who coined the term public use in the Fifth Amendment, and as opposed to, for example, public benefit. And I believe it was a bit of a compromise, and fortunately it was, because at least on the federal level, one can reasonably construe public use a lot more narrowly than public benefit, which could be construed remarkably broadly under the circumstances as the interpreters might have wished.
Previously, we had been talking about fundamental element, fundamental right, because we pointed out that once that right becomes fundamental under the Supreme Court, no legislative body can come in and change it. We have been waiting and waiting and waiting for all these years for the Supreme Court since 1937 to come back and say the ownership of property is a fundamental right. We've been looking at every Supreme Court case since then, and not once have we found the word fundamental right and affixed to real property. However, listen to this, written by Justice Roberts. The right to exclude is one of the most treasured rights of property ownership. According to Blackstone, the very idea of property entails that sole and despotic dominion which one man claims and exercises over the external things of the world, in total exclusion of the right of any other individual in the universe. In less exuberant terms, we have stated that the right to exclude is universally held to be a fundamental element of the property right and is one of the most essential sticks in the bundle of rights that are commonly characterized as property. And then we come to Justice Kavanaugh, who concurred. I join the court's opinion, which carefully adheres to constitutional text, history, and precedent. I write separately to explain that in my view, the court's presentation in that national NLRB versus Babcock also strongly supports today's decision. And then he states, Babcock strongly supports the grower's position in today's case because the California Union access regulation intrudes on the grower's property rights far more than Babcock allows. When this same California Union access regulation was challenged on constitutional grounds before the California Supreme Court in 1976. That court upheld the regulation by a 4-3 vote. Justice Clark, Chief Justice of the California Supreme Court, wrote the dissent. And he said, property rights are fundamental. And he concluded that the California Union access regulation violates the rule of Babcock and thus violates the constitutional provisions protecting private property. And when you have a dissent, which even re-emphasizes what the majority has already found, it is a great thing for those of us who practice this. We finally got somebody to say, property right is fundamental. Maureen?
Well, you know, I've never practiced eminent domain or appeared in the esteemed courts that you have, but I've noticed on a very base level, having prosecuted and defended many cases, that there's a reason we have the old saying that good fences make good neighbors, because once one neighbor intrudes on another neighbor's property, bad things happen. And this is a recurring theme, has always been a recurring theme, and the fact that we now have our highest court recognizing this as a fundamental right is really a predicate to stave off some of the critical race theories, that intrusions that may be coming, and it's really a good day for all of us, I think.
I think to your point earlier, the societies that have embraced protection, vigorous, deeply held, culturally valued protections of property happen to be the same ones that take the same approach to human rights. The two are part of the same basket, and it's very difficult to effectively distinguish, and thus far has not, there's not a successful track record of attempting to do so.
I thank you both, and I thank you for the opportunity to express our background and discovery of what property rights really are, and now we are known that they are fundamental. Thank you.
Thank you.